Hello, and welcome to Oliva Gibbs' Energy Education Series. Welcome to our webinar, Murky Waters. We are going to talk about all things produced water, being the laws and regulations regarding produced water and what's to come. My name is Isabel Huntsman, and I'm an attorney out of the Houston office, and I'm joined by...
Hi, my name is Baylee Pearce, and I'm also an attorney out of the Houston office.
Our information is here on the slide, so if you have any questions related to what we talk about today or just want to chat, feel free to reach Baylee or I. We'd be happy to talk to you. Alrighty, so topics for discussion today. There are a lot. So first, we're going to talk about produced water, how it's created, what it is. Then we're going to talk about the laws and regulations regarding produced water, which will lead us into Cactus versus COG, which was a Supreme Court case that was recently decided on by Texas in late June. But actually, as of recently, a couple weeks, there was actually a petition for a motion rehearing, which we'll briefly get into later. Then we're going to talk about the importance of produced water and all the possible uses and reuses that come with that. So with that, you're going to hear the term produced water a lot today. Apologies in advance. And let's get into it. Now, let's lay a foundation. What is produced water? Put simply, produced water is a waste byproduct of oil and gas production. How is it created? Most often, hydraulic fracturing or fracking creates produced water. Now, fracking is a technique that involves blasting fracking fluid at a high pressure into a horizontal well, which results in the creation of fractures or the widening of existing fractures, and it allows trapped oil and gas to flow to the surface. The fracking fluid blasts into those horizontal wells, and it's usually a mixture of sand, chemicals, and water, fresh water to be exact. After it's injected and returns to the surface through the well, the hydrocarbons are separated, any recovered water is stored, and the remaining fluid, known as produced water, is then transported to facilities to either be disposed of or treated. Now, historically, produced water has been viewed as waste, and as such has been categorized by the state of Texas as fluid oil and gas waste. This definition includes a variety of laws and regulations to abide by.
As Isabel said, there's now a need to regulate this produced water. As such, the Texas Natural Resource Code defines produced water under fluid oil and gas waste. Under this code, the designation of the waste results in the handling of produced water requiring the appropriate permits, infrastructure, and regulated disposal. This definition is used widely across varying codes that we'll talk about today. And on top of the definition, the Texas Natural Resource Code also provides for default ownership roles. Section 122.002 states that unless otherwise expressly provided for in a legal document, when fluid oil and gas waste is transferred for beneficial use, it's owned by the person who takes possession of it until it's transferred again. It doesn't exactly say that, but it's a really long code, and that's the best summation. On top of definitions, we wanted to highlight different permitting rules that will be of importance later. To lay the foundation, authority over underground injection of fluids produced as a result of oil and gas exploration and production activities has been delegated to the Railroad Commission from the EPA. The first rule that we want to highlight is statewide Rule 9. It can be found at the Texas Administrative Code under Section 3.9, and it governs disposal wells. Every applicant who proposes to dispose of saltwater or other oil and gas waste into one of these wells must obtain a permit from the Texas Railroad Commission, and the disposal shall be in line with the requirements set forth in this rule. On top of this rule, you would also have to comply with Chapter 27 of the Water Code, which is colloquially known as the Injection Well Act, and Title 3 of the Natural Resource Code. We've already seen Title 3 of the Natural Resource Code today. Those were those definitions from the last slide. This rule outlines different geological requirements, different application requirements. I do want to highlight one thing from the application requirement that I thought was interesting. When you file for an application, you must also give a survey showing the locations of any historical seismic events within the circular area of 100 square miles around that disposal site. thought that was interesting. There's also other like logs and maps you might have to provide. There's also, the notice of an opportunity for a hearing for the affected persons. And then once the well is in place, then there are different monitoring and reporting guidelines that are set forth in this rule. We next wanted to highlight statewide Rule 46, which is found in the Texas Administrative Code under Section 3.46. This governs injection wells into productive reservoirs. And any person who engages in fluid injection operations into reservoirs productive of oil and gas or geothermal resources must obtain a permit from the commission. The rule kind of mirrors statewide Rule 9, but it applies to injection wells. So when you think injection wells, think secondary recovery. Isabel will go into this further later. On top of the current legislation, we also wanted to highlight some legislation that just went into effect September 1. We have House Bill 49, which relates to the treatment and beneficial use of fluid oil and gas waste. Importantly for this conversation, it adds tort immunity for those involved in the beneficial use. This is important because it will incentivize oil and gas operators, landowners, and service providers to treat and reuse produced water instead of just disposing of it, which is important as we see Texas's growing water shortages. Next, we have House Bill 4426, which changes permit durations and the renewal processes for commercial surface disposal facilities, essentially just establishing clear guidelines. The last legislation we wanted to highlight, and there's more, we just wanted to highlight the top three. We have Senate Bill 1145, which authorizes the Texas Commission on Environmental Quality to issue permits for the land application of produced water, tasking the TCEQ with establishing clear regulatory standards. This is interesting because beforehand, the regulation was split between TCEQ and the Railroad Commission, depending on whether the water was to be discharged into water bodies or land. And then finally, on top of the legislation that we've already discussed, we also wanted to discuss a little bit about the Produced Water Consortium. The purpose and core function of the Produced Water Consortium is to combine information and resources to study the economic and technological technologies related to the beneficial use of produced water. It's to guide the establishment of permitting and testing standards. So it does things like informs the TCEQ and Railroad Commission on permitting and treatment standards that they should adopt. Like I said, suggests changes to the law and administrative rules and to increase use. Really interesting thing right now, the Texas Produced Water Consortium has initiated these pilot programs, and one of interest today is they have one in the Permian Basin, which analyzes both raw and treated produced water to understand feasibility, quality metrics, and economic viability for broader reuse. This is interesting because we'll later discuss the Permian Basin has very salty water, and so it can't be treated like every other type of produced water. And it's really important to have this Produced Water Consortium because it bridges research and policy gaps, it supports sustainable water strategies, it promotes cutting-edge solutions, and it encourages broad collaboration. Now that the legislative groundwork is laid, we're now going to move on to the most recent legal battle in the Supreme Court of Texas. And that is Cactus Water Services, LLC versus COG Operating. All right, so let's talk about a little bit about the background. First of all, we have three different parties. We have COG, who's the oil and gas operator. And we have Cactus, who's the third-party water servicer. And then we have the surface/mineral owners. Those are the people who granted the COG leases, granted these produced water lease agreements that we'll discuss later. Those are the parties. Now here's the timeline. Between 2005 and 2014, COG acquired 4 leases from 2 different owners. These leases granted the rights to oil and gas or oil, gas, and hydrocarbons. That's important for later. Then between 2019 and 2020, the surface owners executed produced water lease agreements with Cactus. These agreements gave Cactus the rights to the produced water from the land covered by the COG leases. Then, March of 2020, Cactus informed COG of its rights under the produced water lease agreements, so their rights to their produced water. Cactus said not so fast. They then went to the court and sued for a declaration claiming that COG, not Cactus, owns its own production chain, which includes the produced water in it. Now the question from the Supreme Court is, when an oil and gas lease doesn't specifically mention the produced water, who owns it? Operator or the surface owner? So in front of the Supreme Court was two different viewpoints. So first we have COG, and they say, under Texas law and longstanding practice, the language used includes the right to the oil and gas waste, which includes the produced water. But then Cactus said, no, once the hydrocarbons are separated, the leftover mixture is surface wastewater and belongs to the surface owner, absent any express conveyance of the water rights. Well, what did the court say? The court held that under the typical deed or lease language conveying oil and gas rights, produced water is a part of the conveyance, even though not expressly addressed, and is therefore owned by the operator, not the surface owner. And they did so for two reasons. One, produced water and water are not the same. And two, produced water and hydrocarbon production go hand in hand. So for the first reason, produced water and water are not the same. Just to lay some ground rules, the default rule in Texas is groundwater is owned by the surface owner, but like the court said, produced water isn't water. And produced water isn't water for four different reasons. First, it's toxic and hazardous because it contains things such as heavy metals, radioactive materials, and chemicals, making it unsafe to drink and use directly. Second, it's regulated as waste. As discussed, it's regulated underneath certain codes that describe it as oil and gas waste. So obviously not water. Third, it needs specific infrastructure. And I didn't discuss this during statewide Rule 9 or 46, but part of those rules are a lot to do with the infrastructure needed. So different casing needed, different transportation needed, things that I didn't want to bore you with, but obviously things that wouldn't apply to just regular water. And the fourth reason is just because there's water in produced water doesn't make it actually water. So we can't really use the word water and produced water interchangeably. Water refers to groundwater or surface water that can be used as a resource, whereas produced water is contaminated waste that must be removed to keep the oil and gas production going. So calling it water would just frustrate the purpose of production because surface owners typically lack the facilities to handle it. And even the Supreme Court wanted to mention, just because it's water doesn't mean it's water, or has water in it doesn't mean it's water. They referenced an amicus curiae brief by the Permian Basin Petroleum Association, and this brief essentially listed a bunch of substances that have water but aren't water. So blood plasma has water, not water. Vodka has water, not water. Concrete has water but isn't water. Each contains water molecules, but is not considered water. It's a totally separate thing. Produced water isn't water, it's waste, a byproduct of oil and gas production, and therefore must be treated different. The second reason that the court held that the produced water is owned by the operators and not the surface owners is because produced water and hydrocarbon production go hand in hand. Produced water is always a part of hydrocarbon production when we are fracking. This means the separation of hydrocarbons from the watery substance is always necessary because the hydrocarbons have to get sold and the produced water must be stored and transported off. As such, production has to remain a continuous flow. Production cannot continue unless the operator removes and disposes of that water because, for example, in this case, the tanks could only hold up to 24 hours worth of produced water before it must be transported or injected. And in this case further, Cactus notes the COG had the infrastructure needed to transport this water off because it is incidental to oil and gas production, whereas Cactus had no permits, no infrastructure, and no ability to handle or transport or dispose of the produced water. Also, they didn't have any assets other than the produced water lease agreements. They didn't have any pipelines, they didn't have any disposal wells, they didn't have anything. The second reason that we can see produced water and hydrocarbon production go hand in hand is because the statutory and regulatory authority that gives context to this case confirms the understanding and expectation that waste and hydrocarbon production go hand in hand. The court points to several different codes in the case to give context where the operator is tasked with getting rid of the waste. We talked about the Natural Resource Code, there's the Texas Administration Code, there's the Water Code, and then they also talk about several cases that have come to the Supreme Court where it's been recognized that producing hydrocarbons necessarily produces waste. And so the right to produce oil and gas includes the right and the obligation to deal with that waste. On top of that, the lease documents themselves at issue in this case support the construction that COG was transferred the pollution control responsibilities. So pollution control, the oil and gas waste. The leases vary when it comes to the discussion of COG's pollution responsibilities, but they require them to comply with safety and environmental rules, require them to prevent contamination, and even one of the leases explicitly grants COG the right to construct water wells, disposal wells, and injection wells. Point blank, every barrel of oil comes with barrels of waste. Managing that waste is not optional. It's an inseparable part of producing hydrocarbons. Now, there's also concurrence to this case, which just emphasizes the majority's holding is a narrow one. But I thought the concurrence would be interesting to discuss because it talks about three key issues that weren't cleared up with this case. First, the surface owner's rights to contract differently as to the ownership of groundwater produced and subsequently separated from the hydrocarbons. So I think I've really emphasized that it's owned by the operator unless contracted otherwise. So what happens if it's contracted otherwise? What if the lessor contracts otherwise? All we know is that whoever the lessor is will be responsible for the safe disposition of the groundwater, but we don't really know what else. The second key issue that hasn't been cleared up yet is the leases at issue conveyed the oil and gas, or oil, gas, and other hydrocarbons. What happens to the non-hydrocarbon minerals that were leased? They're still in that produced water. They're still in that watery substance, but you don't get any royalties on it. And those are things such as salt, potash, and then discussed later today, lithium. Is this an economic opportunity lost for the lessors? And third, it's unclear whether the lessee owns royalties on the least produced groundwater. If they don't, it's unclear how parties should account for any profit lost from the beneficial reuse or disposal of the produced groundwater. It's also unclear if there's any implied covenants that are due to the lessor. So, interesting topics to move forward that we could see in front of the court soon. As Isabel discussed, there's one more interesting thing. The plot thickens. There was a motion for rehearing filed by the counsel for the petitioner, so Cactus, on August 13th, 2025. There's two big portions that the motion for rehearing really addresses. First was the reasonable use doctrine impaired or revoked or moved around based off this Cactus holding? And that's because they use this case, Guffey versus Stroud, in the Cactus decision, which has this language that essentially says the grant of oil carried with it the grant of the way, the surface, soil, water, gas, and the like to the essential enjoyment of the actual grant of oil, including the right to consume or waste the same. It's the petitioner's position that the Cactus court really held this as a fee conveyance versus a implied grant of rights to use what's reasonably necessary to the enjoyment of the mineral estate. So the petitioner's position is that the reading at Guffey is that the mineral lessee can use way more than they need to, that they completely eclipse the surface owner's estate. And so it's their position, and they want cleared up by the court, what happens to the reasonable use doctrine in connection with this case. And then the second thing they want cleared up is there was a saltwater case that the petitioner used when bringing forth this case to the court. And the court pretty much dismissed that very quickly and said, you can't use that saltwater case because saltwater is water. And as I've discussed earlier, produced water is waste, not water. And the petitioner's position is, no, we can use that case because saltwater is similar to produced water in the fact that it's harmful to the ground, and two, that it's regulated. And so the petitioner is asking the court to look at that again and say, maybe we should use that case when evaluating this circumstance. So some really interesting stuff coming in front of the court.
Awesome. Thank you, Baylee, for briefing us on all things laws, regulations, and recent court proceedings. Now let's talk about why we're even talking about produced water today. Alrighty, so why do we care? Well, there's two emerging problems tied to produced water in Texas. One, the water crisis due to persistent drought and some other variables. And two, decreasing viability of traditional disposal methods. All right, let's discuss Texas's water crisis. First off, there's a projected water shortage to come in Texas due to a couple things, including persistent drought. Now, stick with me. The Texas Water Development Board State Water Plan, that's a mouthful, has indicated that Texas could face a 6.9 million acre-feet shortage by the year 2070. Now, to put that into perspective, in 2022 alone, Texans used 15.2 million acre-feet of water. Meaning that if water is not managed correctly, by the year 2070, approximately 25% of Texans could have less than half the municipal water supplies they need. Now, that's a lot of numbers and stats, and essentially what I want you to know is a water shortage is in our future if we do not make a plan. Texas's water crisis is also due to the state of Texas's supplying aquifers. Now, almost 55% of Texas's water is sourced from aquifers, with a large supply coming from the Ogallala Aquifer. Now, the Ogallala Aquifer is one of the largest aquifers in the world, and it actually provides groundwater to many states, including many other oil and gas producing states, such as New Mexico, Oklahoma, Wyoming, and Texas. Now, aquifers are managed in a couple different ways, and currently the Ogallala Aquifer is managed as a managed depletion approach. Now, managed depletion is the deliberate usage of an aquifer until it is effectively exhausted. Presently, the Ogallala Aquifer is being drawn from at 6.5 times its recharge rate, which is just accelerating us to a water shortage. It's great. While it's not all doom and gloom, Ogallala kind of sets the stage for what's to come with other aquifers such as the Pecos Valley Aquifer and the Edwards Trinity Plateau Aquifer if we do not get a plan into place. Now, along with water crisis and drought, we also have dwindling disposal practicality of produced water disposal wells. For decades, much of produced water has been disposed of via deep well injection through saltwater disposal wells. And Baylee had mentioned disposal wells versus injection wells. Injection wells are for secondary recovery methods, while disposal wells are strictly for disposal. Now, disposal occurs by produced water being injected several thousand feet below the ground and below the groundwater table, to be exact, and it's injected to deep depths to prevent that waste migration to those groundwater tables. And essentially, it's under extreme pressure at those deep depths, which helps it not to migrate, and it's effectively trapped in those rock formations until it's evaporated eventually. Now, deep well injection comes with some issues. Per the environmental concern, there is seismic activity linked to deep well injection. And this increased seismic activity has caught the eye of the Railroad Commission, who has set into place some tightened restrictions. Currently, there's about 30,000 saltwater disposal wells specifically used for disposal in the US, and 8,000 of those are in Texas. Now, with the tightening of these restrictions, after conducting their own research regarding the link between disposal and seismic activity, the ROC has tightened so severely that they've really pushed producers to jump to shallow rock injection, which I'm gonna get into in 1 second. But along with this increased seismic activity, we also have deep well injection as an expense. So while currently the cost of disposal via deep well injection is cheaper than other forms of disposal, which that price is subject to change, a cost is a cost. And when there may be other alternative uses and reuses of this produced water, possible economic gain, that cost becomes heavy. All right, let's shift back to shallow rock. So like I said, with the tightening of the restrictions, producers have shifted to disposal of produced water into shallow rock, which has proved not to be great. There's many risks that come with this shift. So water levels in shallow rock have become so substantial that they risk swelling and breaching wells, rupturing the ground, contaminating water. It's kind of a mess. And it's really proven that shallow rock injection is not a long-term fix. So now that I've outlined 2 big issues in Texas that are tied to water, let's see how I can give some solutions by using the produced water that is a byproduct of oil and gas production. So instead of just injecting produced water into the ground and not using it for any beneficial use, I am proposing, and by I mean the webinar, is proposing alternative uses of produced water. Now, there's a ton of different uses that have been proposed and, a bunch of great ideas. These are the big 3 that I want to focus on today. The first being reuse for enhanced oil recovery, the second being reuse by irrigation, and the third being reused by municipalities. So produced water can be used for enhanced oil recovery, specifically when conducting water flooding. Water flooding is a secondary recovery method that involves injecting water into a reservoir formation to displace the residual oil. Now, water flooding is kind of great because it can extend a field's productive life and it can result in recovery of 20 to 40% of the original oil in place. This reuse is great because it, 1, results in further recovery of hydrocarbons. 2, it reduces the demand of freshwater resources because we're going to use that produced water instead of fresh water when conducting water flooding techniques. And 3, it reduces overall disposal costs because we're kind of getting a 2-for-1. Next, reuse by irrigation, a fan favorite. Okay, circling back to earlier, the Ogallala Aquifer is one primarily used for irrigation, and much of our irrigation is using fresh water currently. But we can kind of flip it on its head and possibly use produced water for certain irrigation methods. So it's in the early stages of development, but treated produced water has the potential to be used for irrigation methods for certain crops. And those crops mainly are those that are not for direct consumption, such as cotton or alfalfa or hay. And we've seen that they've suffered minimal negative impact, but they've actually had some positive impacts, which has been kind of a twist. They've showed signs of improved carbon levels in the soil, improved pH levels, and even some micronutrient availability. Now, further, some crops look to even be thriving, such as guayuli. And guayuli, I believe I'm saying that right, is an interesting crop that's gaining some attention because it can be an alternative source of natural rubber, specifically for latex. Now, this crop, a study is being done right now by the Texas Alliance for Water Conservation, and it actually is supposed to conclude in August of 2025, so last month, focusing on guayuli specifically, as it has been found that guayuli may be able to tolerate high levels of salinity, which would be great to use produced water. So it makes it essentially the perfect crop to try out this method and possibly produce better latex materials. Along with irrigation, produced water may be used for municipality purposes. Now, these uses range from cement production and firefighting to dust suppression for roads and landfills to even produced water being used for the cooling of data centers. Now, AI is booming, as we know, and that means a lot is overworked, and these AI data centers are hot, so they need to be cooled. Utilizing produced water for cooling can free up freshwater resources for other more critical uses. And these reuses really serve as opportunities to reuse and recycle produced water in productive ways rather than just shoving it into the ground and not looking back. Now, along with these reuses, we can also have some economic gain along the way. So there's another option, which is kind of enhanced recovery in a different way, which is the extraction of valuable minerals from produced water, which can be very lucrative. Now, earlier in the presentation, I touched on how produced water is created and how it is designated in Texas, that being fluid oil and gas waste. Well, specifically, produced water is a mixture of fracking fluid, hypersaline brine, residual hydrocarbons, and a ton of other substances of varying concentrations. It can also include minerals such as cobalt, nickel, manganese, and lithium. Lithium seems to be, the more popular one right now, and so we're going to focus on that. So while all these minerals I listed above have marketability, lithium has stood out amongst the rest. Especially in Texas, we have high concentrations that have been reported of lithium within produced water. So why has lithium taken the lead? Well, it's piqued the interest of many, partly due to the global lithium market. Right now, it sits at about $24 billion currently, and it's expected to rise anywhere from $55 billion to $75 billion by 2030. That's only 5 years. These projections are based largely by demand for lithium-ion batteries for electric vehicles and also some energy storage systems. Many notable oil and gas companies have actually invested in these lithium projects, with likely many more to come. And Arkansas is the leading state. They're leading the pack right now with advances surrounding lithium extraction, and most recently have actually set a royalty rate, which is huge because it really looks like lithium production is here to stay. Now, let's talk about some traditional lithium extraction techniques really quick. Two in particular, we have hard rock mining, spodumene ore, and solar evaporation. Now, hard rock mining comes with low recovery rate of lithium, high operational costs, and truly a plethora of negative environmental impacts. Now, some of these impacts include high carbon emissions and just destruction of land. Then let's flip to solar evaporation. It's not too great either. And aside from the negative environmental impacts, an average of 500,000 gallons of water have to be used to produce just 1 ton of lithium. So if we want to talk about water scarcity, that's not great for us. This process also takes years, and the recovery rate is relatively low. But let's talk about produced water. So with the presence of lithium in Texas's produced water, direct lithium extraction, or DLE, is the most recent up-and-coming technique to use. And essentially, it acts as a big, huge magnet. So direct lithium extraction pulls lithium from produced water as a magnet would, and it essentially grabs all of the lithium ions and leaves everything else, the water, the other hydrocarbons, the other minerals in the water, and it pulls out lithium. So DLE is significantly more efficient than the other two I described, and it offers a more favorable environmental impact by a long shot. So, as demand for lithium continues to surge, direct lithium extraction could prove to not only keep up with demand, but also transform produced water from trash to treasure. Now, as produced water continues to serve more as a resource than waste, we will likely continue to see more litigation in the courts revolving the ownership and use of produced water, as well as some modernization of current rules for reuse and disposal. Additionally, Texas will continue to grapple with increasing water scarcity and the decreasing feasibility of traditional disposal methods. So it might be wise to start looking for alternative uses of produced water. The good thing is we have an opportunity to turn trash to treasure, like I said, and we've talked about a ton of different uses, and there's plenty more to come. So if you want to get creative, go ahead. Now, if you have any questions about what we talked about today, or would like to discuss further how produced water can be reused or recycled, please reach out. Once again, our information is on the slide here, and if you have any questions at all, Baylee or I would be happy to talk to you or just to chat. Thanks so much for attending our Murky Waters webinar over all things produced water. Have a great day.